of a sudden we heard this loud bang at the door. It's like they got rammed and hit the door.
He told us to get from under the bed, but it'll blow our brains out our head. Put our hands in the air, we have guns in our backs and in our heads.
The man was outside with the infrared. On you as you're walking down the stairs, you can see it as you're walking down the stairs on your shirt.
In late April 2002, the United States government, in conjunction with the Justice Department, the FBI, the GBI, the Department of Natural Resources, U.S. Forestry, multiple sheriff departments, and law enforcement agencies, invaded and raided 404 Shadydale Road, Eatonton, Georgia, Putnam County. They came with the intention of murdering innocent men, women, and children. This was obvious because of the massive display of automatic weapons, helicopters, riot gear, the overwhelming enormity of armed manpower, armored vehicles, refrigerator trucks, and the display of body bags.
The leader was arrested. There was a huge FBI Waco-style raid.
Virtually all of my personnel, well, don't get me wrong, there's still deputies on patrol, but other than those on patrol are here, along with approximately 20 from the Columbia County Sheriff's Office over in Athens, Georgia, maybe 15 to 20 from the Baldwin County Sheriff's Office in Milledgeville, another 15 to 20 from the Jones County Sheriff's Office in Gray, Georgia. There's 2 DNR personnel here and 2 federal United States Forest Service personnel, and there were probably at some juncture in time close to 200 FBI agents.
Why didn't you so many, and how come they got machine guns and cannons and helicopters and bombs?
Well, I would suggest that you ask the FBI why they have their equipment.
I thought you were heading this investigation, Sheriff Seals.
Did you not understand my response? I would suggest you ask the FBI why they had helicopters and things, as to why my officers have weapons that they have.
Are they threatened?
I ordered them to possess those.
Are they threatened by the people on this land? Excuse me.
Since the group moved to Georgia, it has been perceived as a threat to public order, as a dangerous, potentially violent Black Panther-like, quote, racist organization that's planning to, quote, take over the county.
The judges work together, the lawyers are working together, the building inspectors working together, everybody's all teamed up in a little KKK clique down here.
The group does not have a history of violence, and yet the FBI's 2002 military raid on Tamaray involved armored trucks, tear gas, snipers, helicopters, mounted with machine guns, not to mention body bags and a refrigerated van.
what's important on that, Dr. York's attorney at the time filed a motion to change the venue in the case. And generally, the reason you file a motion to change venue is if there's a lot of pretrial publicity that you think would negatively affect your client. In this case, that was done. The judge found in the order that the Middle District and the Atlanta Media Markets districts were tainted, and he had a grave concern. I remember that specific word, grave concern, about whether or not there could be an impartial jury picked from this area. So basically, he ruled in his order that those markets were dead as far as a fair trial for Dr. York being able to pick a fair jury. Thus, he moved it to Brunswick, which he felt was a, impartial market. And that's an issue too, but let's just stick with the Middle District. After that ruling, even though the government knew that the judge's interpretation was that there were biased jurors in the Middle District and Northern District, the government went to this same jury pool to obtain the superseding indictment. They picked the grand jury from people that were established as biased, potentially biased or definitely biased or whatever, where the judge had great concerns, and picked the grand jury. Our argument was, and our motion was, look, if you've already ruled that this jury pool is tainted, then the government should have picked the jury from the new market, not the old market. So we don't even get to the question of, the question stays at that. If that jury was picked from that market, then that jury was the grand jury as well as the trial jury were tainted. The court didn't agree. Basically, the 11th Circuit said that the purpose of the grand jury was prosecutorial. However, the original intent, and I put this in the brief, the original intent of the grand jury was dual: to establish that you should go forward with a justified crime, or release people that are innocent if the allegations are unjustified. So it's a dual purpose. But you cannot successfully meet the standards of a dual purpose if you already have a biased pool of jurors. It was a very simple thing to pick jurors from another circuit. You follow me? And it was nothing that would have been too laborious for the government. We picked the entire trial jury from there. And our basic point was that that indictment should be dismissed because of that. How they get around that, I think the 11th Circuit kind of skirted around it. But the point is, you had already established that pool of jurors as biased, and that was the purpose of that argument.
I think it's also fair to note, too, that that position was laid forth by Attorney Patrick when he got his case around December 12th, December 16th.
Right, when we first got it.
All right?